If I call to order the Board of Trustees meeting for the Long Beach Community College District for September 23rd, 2014. This is calling to order for items in closed session. Those items are AFT negotiations, CCA negotiation updates, both, and personnel pursuant to Government Code section regarding a public employee employment discipline dismissal release. No actions at this time. Madam Secretary, if you could please call the roll. Don't we need that? We don't need official roll? I don't need to. I can do it later. Okay. Trying to follow all the Brown Act. Then at this time, Madam Secretary, we have one speaker, correct? Thomas Hamilton, wishing to speak before the board on these items. And also thank you for being the first person to realize that this is the area you speak at, and not the board meeting. Your name for the record?
My name is Thomas Hamilton. I'm the AFT president here at Long Beach City College. Good evening, President Oakley, President Kellogg, Board of Trustees, and the public. I'm here to address a discipline issue as far as with one of our classified employees. And first of all, I'd like to state that I think this employee was denied the due process as far as in the discipline, as far as in the accusations and the allegations that were placed on her. I have a few documents that I would like to read to you, and bear with me. Some of them may have small print, so I might have to put some cheaters on to deal with this. This is from the Community Care Licensing Division. And it states, the purpose of an unusual injury reporting requirement is to provide the opportunity for the licensee to explain how or why the incident occurred, what action has been taken, and the results of the incident to prevent further incidents, and to go protected of the client. Reporting requirements require a licensee to report to the CCLED, telephone or written 24 hours in event listed by the Health and Safety Code, HSC, section 159.467B1, and the California Code of Regulations, CCR, section 10416.2B for family child care homes, and the FCCH, and I know this is a lot of things, and I'd like to have a copy if you guys need to at the end. Any events listed in the CCR section 1021D and 1 Child Care Center CCC that occurred during the operation hours. In addition, some circumstances may require the licensee to inform other local authorities such as police, sheriffs, and local health departments of county child protective services of the incident. A written report should suggest the child's name, age, sex, and the date of the admission, date and nature of the event, attending physician's name and findings and treatment, if any, and disposition of the case. Licensees are to document the events described in HSC section 159.46B1 and CCR section 1012D1 and the unusual incident report licensee 6244 child incident injury report must be submitted to the CCD within 7 days of the event. Upon receipt of the report, the licensee program analyst must determine whether the incident warrants an immediate case management to visit the facility or a follow-up. Although the unusual incident report is not recorded as a complaint, the same steps may be applied to assist the investigation, such as to interviewing the victim, witnesses, and collective documents. In case where another investigative agency has conducted an investigation prior to the CCLD, a copy of their report may be sufficient. Additional interviews or facility visits may not be necessary. Lastly, licensee are to notify the parent, authorized representative as soon as possible when there is a reasonable case that a child in care has suffered any injury or been made immediate notification to the requirement. A parent conference may be convened to discuss the nature of this event. In the center of these allegations, as far as like with one of the students, I want to read I want to read a letter. I will omit the names because of confidentiality and because this is a ongoing investigation. This is dated August 27th, 2014 at 16:16 hours. Says, good afternoon. Around 2:02 p.m., I entered the PCC CD Center to pick up my son for early for his class. I was being waved in to come in to the principal's office. The supervisor had asked how she had been doing, and she had said upon and stated that she was doing okay. She then followed me with asking me how my day was going. She said the reason for me coming into the class is to let her know what was going on with the center in the case against a classified employee. I stopped her and stated I did not want to be any involvement in what was going on. She asked if I had heard anything, and I stated no, because I didn't. I have heard bits and pieces about the individual not returning, but the reasons were never stated. To whom I spoke with parents or some of the staff had been nonchalant with gestures on this matter. She then proceeded with, well, your son was brought up in a meeting in regards to the same teacher that is being terminated. And I repeat, terminated, not disciplined. And at the incident that occurred, I asked, well, when was this and why wasn't I notified about this matter? I told her I should have been notified about this the day that it happened or 24 hours within the happening. She stated no, which he has never said anything about me. Pretty bright child, and he would have let me know if something happened to him. She looked at me with this question look because I kept asking her when did it happen, and she could not give me a date. Now, I just read to you as far as what the licensing authority says that within 24 hours of an incident that it needs to be reported. And that within 5 days, a written report needs to be filed with the exact time, place, incident, and the occurrence and what happened to the child. This case, this was not done. She looked at me with a question look and says, I kept asking her when did it happen, and she could not give me a date. She stated that just thinks that whoever brought it up had a hostile tone in their voice and that it should blow off. I then said, I was pretty upset that all of this was happening. My son would have brought it up to me, and it did not blow over. It was going to be a problem because myself as a parent should have been notified immediately. Even if it wasn't true and an investigation should have been taken, I should have been made aware of it. She knew I was upset because she kept saying, well, that is why I'm telling you everything is going to be okay, and she would keep me updated with the issues of my involvement. I walked out of the office. And this is by one of the mother of one of the sons that were allegedly involved in this incident in the CDC area. So I find it very confusing and alarming that one incident took place, wasn't reported within the allotted time according to the state. The parent was not informed that their child had either been victimized or was a subject of an ongoing investigation pertaining to a teacher as far as like at the CDC center. Okay?
Thomas, could you make sure that all that documentation you can give it to our board secretary so it gets distributed properly?
Yes.
Okay, thank you.
Another notification that I would like to read to you. It's California Penal Code, Section 1165.7. As used in this article, a mandated reporter is defined by any of the following: a teacher, an instructional aide, a teacher's aide assistant employed by a public or private school, a classified employee of a public school, an administrative officer or supervisor of a child's welfare and attendee, or a certified public personnel employee of a public private school, an administrator of a public or private day camp, an administrator or an employee or private youth club. And it goes on to list, because basically everybody in this room is a mandated employee. If something happens within a child as described in this, is anybody under the age of 18. 95% of the students in CDC are 4 years or younger. Most of us, as far as like on here, we're only dealing with adults, so we don't come into a lot of cases as far as like with dealing with mandated reporting. Now, same penal code, section 1166.05C. A mandated reporter who fails to report an incident of known or reasonable suspected child abuse or neglect as required by this section is guilty of a misdemeanor punishable by up to 6 months confinement in a county jail or by a fine up to $1,000 or by both. That imprisonment and fine if mandated reporter intentionally concealed his or her failure to report an incident known under this section of the failure to report this is a continuing offense until an agency has specified in section 116.9 to discover the offense. We have, if there was some incidents, why weren't the incidents reported? We have violations as far as like of penal code in this area, and we also have violations as far as like in the state, as far as mandated by the state, as far as what the CD Center is supposed to do, as far as in dealing with child. In the first letter sent to the employee dated on May 19, 2014, it gives a description of the violations, alleged violations on here. And I don't know if you have that in front of you or not. But what I think is very interesting, and it really bothers me, is that on January 21, 2012, the employee was brought in to meet with the supervisor with no rep. On August 22, 2013, the employee was brought in again to the manager with no rep. On August 11, 2013, the employee was brought in again with no representation. Another thing, when you look at this document, the main thing that's glaring at you, and if you look at the dates on here, they have a date of when an employee was brought into the supervisor's office and talked about an incident or an occurrence. What's missing, which is really important, is the time, the date, and the place of when it happened. We have almost like 8 different incidents that's listed on here with no exact specifics. The state requires you to have that for each and every incident. In this letter, which is dated on May 19th, all those admissions are not included. So it leads you to believe one or two things. One, that they didn't follow the California code as far as reporting all these incidents, or the incidents didn't happen. And in the second case on that, if there were alleged incidents that didn't happen, you're in violation either of the California code or you're in violation of the penal code. You can't go two ways. Either you're abiding by the law or you're violating the law. There's no gray area in here. And in this case, the CDC Center is violating the law and not adhering to the exact same principles that they hold their employees accountable to, whereas the managers were going to ignore it. Now, and continuing on.
Thomas, I just have a question for you.
Yes.
And I'm not 100% sure, not to interrupt you. Is it 15 minutes? 2 more minutes? Okay. I wasn't sure. You know, we're sort of so you have 2 more minutes, so please continue. I wasn't sure what the timeline was.
Okay. So
And again, all the documentation that you're
I will
referencing
get you everything that I'm reading and talking to you. I will provide you
Thank
copies
you.
of. I don't have that many copies tonight,
that's-
but
no, not for,
Okay.
as long as it gets to our board secretary.
thank
That's
you.
fine.
on April 29, 2014, there was a meeting with the employee, with the 2 managers, myself, and another union rep. During this meeting, the different incidents were discussed and brought up. And during that same meeting, as far as with these managers, my main question is, you have the allegations on here, but you can't say when they happened. And I find it hard to believe that you're in charge of minor kids, and kids are being in harm's way, and you're in charge of them, and you don't have an exact time and date when the occurrence happened. During this meeting on April 29th, this meeting lasted about an hour and a half, and we talked about all the different infractions that allegedly the individual happened. But the one thing that was very interesting is that the manager is aware of an incident that happened on April the 17th. Notification should have went out to the state on April the 18th. CDC did not notify the state until May the 1st, and I'm going to tell you why. CDC and the managers decided they wanted to have a meeting, the meeting that we had on the 29th, and this whole meeting was to do one thing, was to get that employee to resign. Because even after all the allegations were talked about and discussed, and I kept asking, when did these happen? They could not produce a time, date, and place as far as when they happened. More alarming, when I got the letter from a mother or a parent of one of the kids that's in the center of this controversy, was not informed that their son was involved in this. The state mandates that you inform the parent of something that's going on with the kids. CDC did not do that. Now, my question is this. If they knew about the incident on the 17th or the 18th, why do you wait 11 days to report it? Even though first of all, you're supposed to notify within 24 hours, and a written report is supposed to come down in 5 days, and it didn't happen. And the reason why it didn't happen, because the allegations are false. Because if you have this many allegations from one employee or whatever, my question would be, why is the employee still there? The employee has good interviews, don't have any negative reports as far as on the evaluations, and yet within a 6-month period, a good employee went from being a good employee to somebody that did allegedly allegations that would determine as far as termination on it. Now, two things about it is that another infraction is, when I talk about due process, the second letter that was sent to this employee, dated on July 14, which is a termination letter, has the wrong date. Now, the employee hasn't moved, has the same address for the past 13 years, and the district sends it to the wrong address. So how do we have due process? How does the employee come up and stand and fight when they never received this document? How does CDC and the district, as far as justify sending out a termination letter and sending it to the wrong address? When we send stuff out certified mail, it goes with what? It goes with the green postcard that says somebody signed off on it, that they actually received it, and now you have proof of service. That still hasn't happened. Okay, so due process, and then a rush to judgment as far as by the CDC center, having an investigation, and then on top of this, just last week we were back with HR for 2.5 hours talking about other incidents regarding the same employee. Now, we went through the discipline, we went through the Skelly, and now because the district didn't do it right, now they want to turn around and start all over and then do it again. It's like the kids, when they come up, they make a mistake, they say, I want a do-over. When you're talking about somebody's livelihood and their career, there's no do-overs. Either it's right or it's wrong. And in this case, CDC was wrong. They didn't do the right thing, they didn't follow the law, and they didn't do what the California state requires them to do when caring for and having minor children in their care and under their protection. Now, were these kids put in harm's way? If they were, I would think that the managers would have documented this and it would have been noted, and we wouldn't have had to ask for times and dates and places. It would have been in there. I think it's sloppy, because if it's not in there, I'm saying that it probably didn't happen, or the managers are just making something up for whatever reason. Because this, and I don't know what the exact number is, because if you have this many infractions by an employee and the CDC isn't taking care of it, then you lose your credibility, and unfortunately, and would be bad for the college, is that they wind up closing the center. So before we look at and make a decision regarding this employee, we need to step back and look at everything that's going on here. If you have copies of the May 19 letter and the June 24 letter, just look at it and ask yourself, Why is there no times and dates on all these infractions when the manager sat down with the employee that said that they did this and this and this, but you cannot tell me when it happened?
Okay.
If you can't tell me exactly when it happened, I'm going to say that it didn't happen.
Okay, we've gone beyond the time limit, but all that documentation, again, you're going to give it to the board secretary? We don't need copies, as long as it gets to our board secretary is fine.
I will get that to her.
All
Yes.
right. Mr. Hamblin, thank you very much.
Thank you.
No other speakers at this time. We are going to adjourn to closed session. We will come back in session approximately at 5 o'clock. Meeting is adjourned.